Commissioner Bluestone.
Here by Zoom.
Hi, Stuart.
Hey, Bill.
Commissioner Castillo.
Present.
Commissioner McMillan. Here. Commissioner Villanueva.
Here.
Did I say it
Good
correctly?
job.
It's only taken me 7 years. All right. Roll having been called, seek a motion, a second for approval of the agenda. So moved.
Second.
Any objections?
I have a question or two, Bill.
Yes,
Excuse me.
sir.
I was just looking it over and I see that, at least I don't see anywhere that, as you usually do, we're going to have a discussion near the end of when the next meeting is going to be. And I'd like to also, I don't know if we have a old business, new business item that we usually put in, but there's something I'd like to raise for consideration at a future meeting. So I'd like to ask that at the agenda near the end, we add in both discussion of new or old business and discussion of when the next meeting will
We
take
can
place.
put that under an administrative category at the end of it. Basically, we're easy to, the reason it's not on there, it may be omission. I would like to think it's because I'm not gonna be here, so I have no input on that, which. Right, Jeremy?
That's right, but we could discuss it. It's probably.
Yeah, it's just, yeah, you all can have a great discussion. That's fine, I'll put that in there. All right, with that, there's a motion, a second. Any objection to approving the agenda? Hearing none, the agenda is approved. Approval of the minutes of the April 17th meeting. Is there a motion, a second? So moved.
Second.
Okay, any objection?
Yeah, I also want to ask about a change in the minutes on the discussion of the voting structures of ethics commissions. I made a comment at the meeting that I wasn't making a motion, but that I wanted the commission to consider when it reviews legislative recommendations later in the year to vote on whether to recommend a change in the voting requirements to make it be at least 5 votes, including the 2 Republicans and the 2 Democrats, so that then the non-major party member could have a determining vote. And I just think it's something we ought to note in the minutes, because I did say that at the meeting and I reviewed it with Amelia.
That's fine. Could you make
Jeremy.
specific reference for Amelia's? You got it? Amelia just gave me.
She has it.
We'll make that edit. So with that, or are there any objections to approval of the minutes of the April 17th meeting? Hearing none, the minutes of that meeting are approved. All right, on to the meteor portion program. Item number 4, advisory opinion 2026-07. Paul Biederman, nice to see you. The floor is yours.
Thank you. And for those who don't know me, I'm my consultant to the commission, and I'm enjoying very much working with Ray Sue and with Jeremy and the staff. The 2026-07 advisory opinion was a request that came from a county commissioner who's running unopposed for election. The issue is whether that commissioner can, under the Campaign Reporting Act, use campaign funds during their campaign to create informational media about a public issue. And the intention is to raise public awareness for this issue. The staff have drafted this opinion, allowing the expenditure as related to their campaign. Even running unopposed, the candidate is still expected to identify to the electorate their concerns and priorities for the upcoming term of office. The issue is whether the proposed informational campaign would constitute a permissible campaign expenditure within the meaning of the Campaign Reporting Act, Section 1-19-29.1A. County commissioners are not entitled to use campaign funds to support their performance of their duties in office. An exception that's only available to legislators, not to anybody else who's elected. And all candidates for elected office are prohibited from using campaign funds for personal expenditures, which the act defines as expenses that would have existed regardless of the official's candidacy for public service. But the opinion provides a number of reasons why even unopposed candidates for public office can, under the Campaign Reporting Act or the rules that the Secretary of State promulgates to implement that statute, why they can appropriately use campaign funds to bring issues to the concern of to the attention of the public. And that these reasons include promoting voter awareness of the issues to be addressed by the body and laying the foundation for holding the official accountable for their performance in office. So that's what this 2026, 07 advisory opinion writes about.
Okay. Is there a motion and a second to approve the issuance of the advisory opinion?
So moved.
Okay, moved and seconded, discussion. Stuart? Yeah.
It's fine with me. It's good.
Everybody good? Okay, let's do a roll call vote on that. Commissioner Baker? Yes. Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan? Yes. Commissioner Villanueva?
Yes.
And the chair votes yes. Let the opinion issue. Thank you.
Thank you.
And the next matter is also yours, Paul, item number 5, advisory opinion 2026-08.
Correct. That 2026-08 involves a contract with a retired agency employee to provide training to the agency staff under the Governmental Conduct Act. As you know, the Governmental Conduct Act provides some guardrails to prevent people from kind of feathering their own nest in private practice or private sector by creating the need for a contract or the opportunity for a contract and then getting the contract themselves. So the state agency asked for an opinion on whether it could contract with a retired employee of the agency to train its staff. And our staff wrote that because the retiree had no role in creating the contract, and because the former employee is not representing anybody else, the Governmental Conduct Act does not prevent this contract from happening. That the retiree had no role in creating the contract is established by the agency in its request. So we respond to the request as written. We don't go digging into it to see if there's anything fishy about it. NMSA 1016-8A only prohibits an agency from contracting with a person who's represented by a former employee when the contract is a direct result of the former employee's action while still employed. Since the retiree is the contractor, rather than representing someone else who wants to be, the section does not apply. And similarly, we have sections 1016-8B and D, and those are both inapplicable because both of those sections relate to the former employee representing others seeking contracts or other favorable action from their former employer as well. So the proposed contract, we believe, is legal under the Governmental Conduct Act.
All right, is there a motion and a second to approve the issuance of the advisory opinion?
Approve.
Second. Okay, it's been moved and seconded. Any discussion? Hearing
Let me
none.
just ask a question.
Sure.
Hypothetically, if one of the staff of the Ethics Commission retires, the commission could enter into a contract with that person to provide training.
That's correct. If they did not arrange for that themselves, if the contract, they had nothing to do with creating the contract, yeah.
So the discussion would happen after they leave the commission.
Or it could occur simultaneously, but if they're on, if the person's not involved in that discussion, they could still be contracted, be a contract.
Anyone else? All right, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. The opinion is issued. Thank you. Item number 6, Ms. Sue.
Good morning, Chair and Commissioners. Today I'm here to talk about advisory opinion 2026-09 about the Governmental Conduct Act and campaign contribution disclosure requirements for a community college board member who is simultaneously serving as an executive director of a nonprofit. And this advisory opinion is split into 3 parts, and there's 3 questions. So I'm going to go through the questions one by one. The first question is, under the GCA, can a member of the community colleges board also serve as the executive director of the nonprofit when the nonprofit is receiving grant funding awarded through the college through a no-bid small professional services contract? So part 1 of the opinion starts with a discussion of section 10-16-7 of the GCA, and it explains what a substantial interest is under the GCA. And it concludes that nobody can have a substantial interest in a nonprofit since nonprofits can't issue shares. And so there's no violation of 1016-7A, but we wanted to just include this just in case because it is relevant. And then part 2 of the opinion explains that the board member would be permitted to hold the dual roles under the GCA so long as the board member complies with subsections 1016.3 and 1016.4.2 of the GCA. And there are 4 requirements for the public officer under the GCA. The first is that they have to fairly and impartially effectuate their duties as a board member. The second is that they have to avoid using their position as a board member for personal or private gain. The third is that they have to adhere to certain recusal and disclosure requirements under the GCA. And the fourth is that they have to disclose their employment in writing as the director of the nonprofit to the community college. That's question 1. Moving on to question 2. This question asks, under the GCA, may the board members seek out other services from the community college for the nonprofit, such as office space and intern assignments through memorandums of understanding? And the answer to this question is yes. They can do so under subsections 1016.3A and C of the GCA and section 1016.6 of the GCA, so long as they avoid any favorable treatment. And this means that they have to do 3 things. The first is that they have to fully disclose any conflicts of interest. The second is that they have to properly recuse themselves from official acts when it's appropriate. And third, they have to not use any confidential information as acquired as a board member for the nonprofit's private gain. And then the third question for this advisory opinion, which is very, very long, is under the procurement code, is the board member who is serving as the executive director required to disclose campaign contributions to themselves in bidding for a contract with the community college? And the answer to this is yes. Under the procurement code, board members must disclose campaign contributions over $250 that were given or received within 2 years before signing a contract. And the requirement also applies to their family members and representatives. And if the board member doesn't disclose their contributions, it just means that the contract can be canceled. Any questions?
Thank
No
you.
questions, but just a comment.
Take a
that,
breath in here, or was that all?
I did
Yeah.
speech and debate in high school, so I'm ready to go.
Yeah, it was great. I mean, that's what in the film world, that was just a one take. All right, is there a motion and a second?
So moved.
So moved.
Thank you. Any questions or further discussion?
If I could, Mr. Chair, I just want to commend Grace. These opinions that she's been writing, and now this one is a formal commission opinion, or continuing what I consider to be the excellent work that was done before by the staff and KC. And I just want to thank you for the hard and excellent work that you're doing, and happy to vote in favor of this opinion as well.
Thank you. Yeah, I echo that, and I think we all do. We're really, really pleased with the quality of work. We're also not surprised. We have a long and storied history going back 7 years of such good work. So thank you. All right, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Villanueva.
Yeah.
And the chair votes yes. Thank you. Thank you again. All right, you're still up. Item number 7.
Well, thank you, Commissioner Bluestone and everyone for your kind comments as always. This advisory opinion 2026-10 is about the GCA prohibition on hiring a former agency attorney as a contractor who will represent the same clients for the agency. And so the question presented is whether a former state agency attorney can be hired right away as a contract attorney to represent the same clients under the GCA. The facts presented in the request talk about how the attorney wasn't involved in contract decisions or procurement while working for the agency. So that goes back to sort of what Paul was talking about earlier in his advisory opinion. And another fact is that the attorney here doesn't appear before the agency on behalf of the clients because the agency itself does not hear cases in an adjudicative role. And we just want to note that this opinion doesn't analyze Rule Set 16 of the NMRA regarding the rules of professional conduct for attorneys, although those are very important, they are not within our jurisdiction. So this opinion goes through the different subsections of 1016(8). And first, it explains that the contract doesn't violate subsection A for 2 reasons. The first is that the attorney didn't have any influence on the creation of their contract. And the second reason is that no work was done on their contract while they were still employed by the agency. And next, the opinion also talks about how the contract doesn't violate subsection D of 1016(8) because the attorney who resigned isn't representing clients in front of the agency, which is their former government employer. Instead, they're going to be representing clients in district court. And then we also want to note that the opinion doesn't address subsection C of 1016(8) because that subsection is about local government agencies and not state agencies. So the main analysis here is about subsection B, and the contract would violate subsection 1016(8)(b) of the GCA. This rule is really important because it protects the public interest by preventing conflicts of interest and ensuring that former government employees don't use their prior involvement, their insider knowledge, or their government relationships to gain an unfair advantage after they leave public service. And it prohibits these former public employees from representing people in dealings with the government on matters in which they personally and substantially participated in while working for the government. And we also want to know that this provision never expires, so it's always applicable. And subsection B contains 3 main elements. The first is that the former public officer or employee has to represent a person in the person's dealings with the government. The second is that the person's dealings with the government must be the same matter as one in which the former public employee participated in while they were in public service. And third, their participation must have been personal and substantial. So given the facts in this request, we see that the former agency employee left their government employment, but they're representing the same clients as a contractor. And so because they're handling the same cases involving the same parties and the same underlying facts, we basically determined that these are the same matters, especially that the employee participated in a personal and substantial matter while they were a state employee, so the contract would not be allowed. Thank you.
Thank you again for wandering through that keg of nails for us. Is there a motion and a second to approve the opinion?
So moved.
Okay, moved and seconded. Discussion or questions? Okay, hearing none. Commissioner Baker, what's your vote?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. Thank you again. Nice piece of work. Next, Paul, is you, item number 8. Advisory opinion of 2611.
Okay, thank you. And I'll, by the way, second one other thing, which is Mr. Bluestone's comments about Ms. Sue's work. It's been a pleasure, and I'm looking forward to a lot more time with her discussing her writing, her really good writing and analysis and research. It's been excellent. Okay, so this is an opinion about the permissibility of the paying for legislators' travel expenses by a lobbyist who is a lobbyist's employer. So the question arises under the Gift Act. The Gift Act identifies several categories of persons as restricted donors. And the donation, so to speak, can really be almost anything in the way of payment. So a nonprofit organization that employs a registered lobbyist has asked whether it can, within the limits of the Gift Act, pay the travel expenses for a legislator to attend a ceremony where they will receive an award from the organization. The legislature would not make a speech or provide any other service to the organization. And the trip is unrelated to an election campaign. So the staff determined that such compensation by employers of lobbyists for the legislators' travel expenses is allowable under the Gift Act. Employers of lobbyists are included within the definition of restricted donors, whose gift to public officials are limited under the Act. The amount that's allowable depends on how the compensation is structured, however. The legislator may seek reimbursement for their travel expenses from the legislature itself by claiming the trip as official legislative business. If that is provided, then the organization may reimburse the legislator in full, reimburse the legislature in full for the travel expense that they cover for the person who's traveling. But if, on the other hand, the organization were to pay the legislator directly for their travel expense, that would constitute a gift subject to the limits applicable to the restricted donors. And the Gift Act limits such direct payments to no more than $250 for each payment, with a cap of $1,000 in any one calendar year. So again, if they want full reimbursement, the legislature has to go to the legislature itself, probably the Legislative Council Service, I believe, and ask for the reimbursement for the travel, which would then be reimbursed by the nonprofit. We additionally found that the expense reimbursements are not exempt from limits as honoraria under the Governmental Conduct Act, because the legislator is not providing any service that would constitute an honorarium. And such reimbursements as may be made to the legislator directly are subject to reporting requirements of the Campaign Reporting Act.
Thank you. Motion and second.
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 Thank you. It's been moved and seconded. Any questions or discussion?
Yeah, I've got a question.
Go ahead.
And I understand these things best in the context of hypotheticals. So let's assume that Mr. Lang is a member of the legislature. Let's also assume that he has done a lot of work for a nonprofit called Pause for Pets. And Pause for Pets wants to send Legislator Lang to New York to receive an award. If Commissioner Lang, Legislator Lang, goes to New York and gives a speech about the importance of pets and vets, is a different analysis than if he simply goes, receives the award and says thank you. Is that correct?
Yeah, but not very different. The Gift Act provides, the Governmental Conduct Act provides a limit on honorarium. And that limit is your travel expenses plus $100 maximum. That's interesting because the Constitution has a provision that says you can't accept anything at all. But, assuming that the statute has somehow interpreted that successfully, how to deal with the discrepancy, I don't have an answer for that. But at least that could get the travel expenses reimbursed because it's providing a service like that.
And help me understand the distinction between providing the benefit directly to Legislator Lang versus somehow providing that benefit to the legislature, which would then provide the benefit to Legislator Lang.
I just have to go to the words of the statute. The Gift Act provides that there is this limit on any benefit that can be received, any financial benefit in the form of a payment to a legislator, and that includes other elected officials as well, or really any employee of the government, of the state government, of the state.
But if the legislature is the conduit,
Well, if the legislature is providing the travel reimbursement because they view this as official business for him to go, him or her to go and receive then that would be a reimbursement to the state legislature, none of which would actually be given to the legislator themselves. Although the money would be flowing through, yes. I mean, I'm giving you the statute, not my interpretation.
understood, let me just ask the question, does this come up often enough that when the commission makes recommendations to the legislature about what changes should be considered? Does this particular scenario come up often enough that we might put this on our to-do list or wish list?
Okay, well, my experience working at the legislature, which I've done during the sessions for the last 10 years, I did not see a lot of travel occurring of that nature, but there is travel that is compensated for the legislators to go to interim committee meetings throughout the state, and of course they get them per diem. Every day they work at the legislature. So I would suppose that there might be a fair amount of travel, at least state and possibly out of state conferences of that nature, to probably make it worthwhile to provide some kind of the advisory opinion might well serve that purpose.
Almost says you're, they typically paid by the council service.
I believe it's paid by the council service, yeah.
Because I seem to remember that we had to address an issue where some energy company wanted to do something in the southeastern part of the state. And the question was whether or not it could pay for legislators from that part of the state to go, I think, to Oklahoma to learn about the project and whether that was legal or not. And I wonder how often that happens. And if there's enough uncertainty about it that at least one legislator asked us, is this okay? Is that worth addressing when we make our wish list?
The chair and Commissioner Vega, that's, we did issue that opinion years ago. Holtec wanted to finance legislators to go to see a nuclear plant in Missouri to see how the waste is made. And that question turned on whether or not it was a bona fide educational purpose. And the advisory opinion concluded that it was. And that is another exception to the GIFT Act. I don't think that exception applies in this case. I think Paul has identified a way to allow organizations to reimburse for travel expenses in a way that avoids a GIFT Act problem, so long as the council service is okay with making that payment. And that might depend on council service rules. And so members do go to national conference of state legislature events out of state. There's one in Chicago this year. They recently went to one in Denver. I'm not informed on how legislators are reimbursed services, but our participation there. But I think Paul has identified something that's maybe akin to that, depending on what the trip is for, and so long as council services is on board, I think all we're doing is identifying that it would still be compliant with the GIFT Act in this advisory opinion.
If I may add to that, I think this approach allows the legislative council service to serve as kind of a filter for payments that are appropriate versus those that are not, because the appropriate ones do involve at least something to involve with the legislators' work. And as limited, it's not a gift that we're going to give you $10,000 for going to this conference. We're just going to pay your expenses. That kind of thing can be dealt with by the council service on every time it arises.
And in your experience, does the council service generally do a pretty good job filtering what's acceptable, what's not acceptable?
I have no experience looking into that question for this aspect of things. I will say that I have a great deal of a great deal of respect for the integrity of the council service, having worked in the legislature. I found they were a very solid body.
Thank you.
Anyone else?
Yeah, I have a
Yes.
question.
Oh, yeah, great, sure.
I'm sorry, is that okay?
Yes, please, go ahead.
Yeah, we do a lot of these, and this opinion started as an informal advisory opinion too, that the staff has been great in turning around these requests for advisory opinions very, very promptly. And in sharp contrast to the experience that I think we've all had with the Attorney General's office, these opinions are coming out not only quickly, but in high quality. And this one was done as an informal opinion initially too. I'm curious whether Jeremy or Paul, and it's great to see you here and have you here, Paul, if you have any information that you can share about whether the informal advisory opinion was in fact followed in this circumstance, and what actually happened in the real world in response to this request and the opinion that we issued.
My understanding was that, and I'm sorry, I'm new to this, in terms of the way your operation works, but, my understanding was that because we wrote this as an informal opinion, but then it was requested, I think appropriately by the commission to, consider whether to make it an official opinion of the commission. I don't think we issued it, yet, or did we?
We responded to the original requester, and gave them the information, but they didn't, necessarily tell us what they did. They just said, thank you for getting this to us in time so that if we were to get plane tickets for the conference, we can do so.
So we don't know what actually happened, but it was issued promptly and gave them the information
Yes,
before.
the informal advisory opinion was issued promptly, yes.
Right. And Jeremy, you don't have any more information about that, do you?
I don't, and I mean, if they didn't follow the workaround, I mean, that raises a potential gift act problem. And we might need to look into that to see if they followed the guidance. I can check in with Shauna before she leaves.
I think that would be good. No, thank you.
Commissioner Castillo?
My question is the $1,000 made up of 250, 250, 250, 250. You can't divide that out to say, okay, this 250 is for going, this 250 is for cut, this 250 is for room one night, this 250 is for the second night. How is it because it's one legislator, it's limited to 250, or is that unclear?
Well, the way we read the Gift Act, it's 250, 250, 250, 250. Within a year, any way you want to do it. We don't say restriction on it.
Anyone else? All right, there's a motion and second. There being no further discussion. What's your vote, Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan? Yes. Commissioner Villanueva?
Yeah.
Chair votes yes. Thank you. Thank you all for your good work. Really appreciate it. Thanks, Paul. It's nice to see you again.
A lot of fun working with you.
All right, public comment number one. Amelia,
Thank you, Chair. I'm not seeing any members of the public.
is there anybody here today? Besides us?
We're here, and if
We're here.
I'd like to
Yes.
just introduce some of these new faces that y'all have.
Yes, please, before we go into executive session.
That's what we're doing. So,
Yeah,
let me be more global than that. So Wendy Sharon, thank you for being here. Y'all know Wendy Sharon. They take care of this place, all things ASD, budget, finance, audit, procurement, etc. Thank you. Amy is our case manager, supports us in all of our administrative docket and litigation efforts, is kind of the backbone of many of our cases. Let me start with our undergraduate summer interns. So
There we go, it's you.
So we have Darren Eberhard. Darren is a rising sophomore at Georgetown. Darren is working on a project where he is going through anything that's been written about the history of this agency. And he is working through boxes of records that we received from Dee Dee Feldman and from Cliff Reeves about the history of the creation of this agency going back, I don't know, 4 decades. But Darren probably knows the most about the history of this particular agency at this point than any of us. And so he is tasked to write the history of this agency with the idea that when we're 10 years old, we might do an event where we kind of do a retrospective and celebrate what we've accomplished. So thank you, dear.
So I just wanted to add, are you an archaeology major?
Excuse me, is it possible to shift the camera to see the people Jeremy's pointing to?
Okay, Darren, Rooster, can you walk here
Yeah.
behind Judge Lang so that Stuart can see y'all?
That'd be great.
And then,
Thank you.
Upstairs, it's also an Albuquerque Academy grad, so it's very exciting because another partner.
Cool. Thank you for doing that. Nice to meet you virtually. Sorry. I can't be there in person.
And Mr. Chair, Darren is also an Albuquerque Academy grad, following the tradition of the chair and Grace,
And Becky.
and Becky. Welcome, Darren. Thank you. Okay, next, Mauricia Marquez is a rising senior at Loyola Marymount. And as the commission knows, we've been working with some sophisticated tools to ferret out compliance with the Campaign Reporting Act. And at Loyola, Mauricia has learned those tools, and she's very competent at R. So she's helping Amelia write some code to identify personal use cases through the expenditure file, and helping clean the code and working on different queries on the contribution side as well. So in addition to other things that we might ask Mauricia to do before she goes on study abroad later this summer.
Great.
And yeah, they are exceptionally talented young people, and we're grateful that they're spending some time with us this summer.
Thank you.
Okay, next we're going to our law students. So we are, I think this might be our 6th or 7th possibly class of summer law associates. So we have Michaela Purcell and Scott Piper.
Back yourself.
Well, Stuart can see them right there.
Yeah, I can. Thanks.
Okay. So Michaela is a rising 2L at Creighton, and Scott is a rising 2L at UNM. And much of the work that you're about to hear about when we go into executive session, they've been working on in addition to other projects. So they are doing real work. They're in the weeds with us. And we're also doing our kind of SCOTUS reading group Fridays, where we're reading through some of the major cases the Supreme Court is issuing this term. So it's very enjoyable to work with them. They are also very talented, and it's a real pleasure to try to identify real work for them to dig into, so that at the end of the summer, they have written real work product that they can use for future job applications or courtship applications or what have you. So thank you also for being here, and we really appreciate the work that you're doing. It's at a very high level, and yeah, your professionalism is exactly what we're looking for and what the profession's looking for. So thank you. And that's the rest of us. You kind of
Yeah, as everybody else looks familiar.
yeah.
Jeremy, I can't thank you enough for starting this program. I don't think it was any of on our radar screens, and the idea is kind of nice, but it's more than that. It's really substantial benefit to the agency and to the individuals, and more so to the state. So thanks a lot for doing that. This is not insignificant. So
We have fire here.
yeah, right. That's how. Yeah, Paul.
This is still public comment, right?
Right.
Okay, I just had a brief comment to make, and that is, I was going to go into retirement in December. I filed the paperwork for the bar to go inactive. And then Jeremy calls me and tells me that there's need for someone here for a while to fill in. And I thought back to about 40 years to the year when the legislature actually passed the Commission Act, the creating the commission. And Governor Richardson vetoed it because the composition of the commission, he wasn't happy. I thought, oh, now, and it took decades to make up for that mistake. So I thought about that and all the effort that went into it and how long we've been for this. So I said, well, that'll do it. So that's why I came back. But I'm promising you I'm retiring next year.
Well, I think it's great for the younger people to have your mentorship and guidance, I'm sure. Well, assuming that this motion carries, we will go in with executives. Chair is seeking a motion, a second to go into executive session pursuant to section 1015(1)(h)(3) and 1015(1)(h)(7) to discuss matters identified in section 10 through 10 through 12. Commissioner Baker. Is there a motion? Motion is second.
Question.
Yeah.
Why do they?
It's still in a closed session.
We have to protect the privilege.
Even though
We've done
they
that
have,
every meeting. We do that.
but understand that, but. My question is, aren't they employees? Summer?
They are, but they're not lawyers. And I mean, privilege might extend to Amy, but we're facing off with real counsel in many of these cases. I prefer just to protect the
That
privilege.
was, and maybe weren't, maybe that was just a discussion we had. Yeah, we don't, all right, we don't wanna flirt with that. So is there a motion, a second? Second. All right, Mr. Baker,
Yes.
Commissioner, I'm sorry, Commissioner Bluestone?
Oh.
I'll catch you.
No, I moved him by accident.
I wasn't sure my yes was recorded. I was in the
Yeah,
breakout.
it's a yes, Stuart.
It's a yes.
Okay, thank you. Commissioner Castillo,
Yes.
Mr. McMillan? Yeah. Commissioner Villanueva?
Yes.
Chair votes yes, we are now in executive session. Thanks. Is everybody
Okay.
here?
Okay, Amelia, now I'll join.
Let's take a 5-minute. Sure.
Sir.
Curiosity, what is the adjective rise
section, and that the matters discussed in the closed meeting were limited only to those in motion for closure. So let us now return to the agenda item number 13. Becky?
Dear Commissioners, staff seeks issuance of an order of dismissal in 2026 NPO 6 in rate mission of Bella Garza.
Is there a motion and a second?
Second.
Any discussion? Okay. Voting on the motion, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Castillo,
Yes.
Commissioner McMillan. Yes. Commissioner Lewa.
Yes.
And the chair votes yes, the matter is dismissed. Thank you, Becky. Zach, item 14.
Thank you, Chair and Commissioners. Pursuant to section 1016G11 of the State Ethics Commission Act, I'm requesting authorization for the investigation and administrative complaint number 20.604 to continue with 90 additional bids.
There a motion and second to some extent?
So,
Thank you. Any discussion? Hearing none. Commissioner Baker,
yes.
Commissioner Bluestone,
yes,
Commissioner Castillo,
Yes.
Commissioner McMillan.
Yes.
Commissioner Lewa.
Yes.
Chair votes yes. All right, item number 15. Roman numeral 1, up the next three are yours.
Thank you, Mr. Chair, members of the commission. I seek authorization to make demand and if necessary, file a civil action against New Chapter, New Mexico and its capacity of the political committee and the nonprofit to enforce the campaign reporting act.
There's motion and second.
so moved.
Thank you. Motion and second to authorize the demand for civil action to enforce as written and outlined. Is there any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Lewa.
Yes.
Chair votes yes. The next item is 15, Roman numeral 2.
Thank you, Mr. Chair, members of the commission. I seek authorization to petition district court for the issuance of subpoenas related to the enforcement of the campaign reporting act against those entities we spoke of here in closed session, and if necessary, file civil action against them. The same.
Thank you. Is there a motion and second to so authorize?
so moved.
Second.
Thank you. Any discussion? Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Lewa.
Yes.
Chair votes yes. Thank you. 16, Roman numeral 3.
Mr. Chair, members of the commission, I withdraw this authorization.
Okay, item number 15, Roman numeral 3 is withdrawn.
Mr. Chair,
Yeah,
I believe that you want to recuse.
I did want to recuse on that second one, so I was gonna note, I was one off on that, but I was sure I had my. So item number 2, the vote is all commissioners present in favor except the chair who recuses on that matter. Thank you. Okay, 3 is withdrawn. 4, Jeremy.
Mr. Chair, members of the commission, the staff seeking an authorization to petition a district court for the issuance of subpoenas related to the enforcement of the Governmental Conduct Act and public authorization to intervene as a party in Region 24 in related litigation.
Thank you. Is there a motion a second?
so moved.
Thank you. Motion a second to authorize the intervention. Commissioner Baker.
I believe that's the one I'm recusing on.
Okay. Commissioner Bluestone,
Yes,
Commissioner Castillo,
Yes.
Commissioner McMillan.
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Thank you. And Roman numeral 5.
Chair, members of the commission, the staff seeks authorization to initiate a civil claim to seek injunctive relief against the Cabinet Secretary of the Corrections Department in her official capacity only, under the Non-Disclosure of Sensitive Personal Information Act.
Okay, is there a motion and a second to so authorize?
So moved.
Thank you, there's a motion and a second,
Second.
yeah, any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Houston,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan. Yes. Commissioner McMillan.
Yeah.
Chair votes yes. All right, thank you. Public comment?
Item 16. Search for next.
Can I have
Public comment. Not seeing any members of the public chair, unless there's public comment from folks in this room.
no, but at Commissioner Lewiston's request, this is a good time to chime in on when y'all want to have your next meeting. Typically, it would be set for the first Friday in August. What date is that?
August 7th.
August 7th.
I might be out of town, but that's okay. I can try to appear by Zoom.
I will also not be here.
Do we need to go to the 14th?
I would prefer that.
14th, Jeff, you good with that?
I'll make it work.
How about August 14th? Everybody good with that? Okay, the next meeting is set for August 14th. Okay, anything else?
Yeah, I had an issue I wanted to just raise for future commission consideration. Given the absence of Judge Klingman today, it seems to me that it's worthwhile considering whether to amend our procedural rules to allow for proxy voting by commissioners if they're not physically able to be at a meeting like Judge Klingman was not able to be today. So I just raise that as a matter to be considered and for the staff to look into it, to maybe review what other commissions like ours do and see whether we want to consider amending our procedural rules to allow that at some point.
Thank you. All right, nothing else? Then we stand adjourned. Thank you very much on everybody. It's been a nice ride with everybody. Thank you so much. Terry, Julia, who were the new kids. For those of us that were here on this first thing, but it's been a joy working with you all. It's been a joy working with the staff. I can't tell you how much trepidation and how many reservations I had when I was called to do this. It all went away in a matter of months, which seemed like decades ago, but it's really been great. Jeremy, we've figured this out, how to deal with each other pretty easily, and hopefully we'll still meet for lunch at Frontier or someplace less attractive. But thanks, everybody. It's really been a joy, and I wish you all the best.
Well, I'd like to say something.
Hopefully, with Governor Carruthers and maybe Francis Williams,
Okay.
who we need to bring into this before the.
I'd have dressed up.
You
if
don't
I
need
knew the game was coming.
Stuart, I'm going to end this meeting and start the other.
Okay.
Okay, see you.